It is day 16 of the Karen Read Retrial. It's May 15th. It's Thursday. Could be a Monday, could be a Friday, who knows? We are going to be doing more of the same today, I suspect, because yesterday we did quite a lot of scientific evidence, and I suspect today is going to be quite a lot more scientific evidence. The lab technician, the forensic analyst 2 who was on the stand yesterday is still under cross-examination. Will the sticker that's one sticker mirror reflected in the SUV come back up today? I suspect that it will, because we still have a whole redirect to get to.
No further questions. Again, thank you for answering my question.
All right, Ms. Harnett, you are all set.
I wanted to correct something from the record yesterday. I wasn't sure when was appropriate to do that.
Okay.
What?
Do you recall which lawyer asked you the question?
Yes, Mr. Alessi asked me the question.
Your Honor, are we going to proceed along with that?
So why don't I see you outside?
Thank you.
Oh, I bet she wants to correct the record. He didn't ask her about it. Oh, boy. She just had some time to think about it. You guys
I'm
have
going to let you step down because questions from both sides are completed.
Okay,
so
thank
you, though.
The court's like, nope. And the DA's like, nope.
Undetermined is a term that is used and that you use. And does that mean that when the information pointing to one manner is not more compelling than other reasonable possibilities, or the death investigation lacks sufficient information to opine on a manner of death, at the time of death, the certificate is signed? Is that generally correct?
Yes.
That is such a good question. It got a little long at the end, but that is such a good question. He brings this in all of his cross-examinations really well. I appreciate when he sticks with reasonable interpretations. Remember, at the end of the case, when the jury gets the jury instructions, they will get an instruction about circumstantial evidence. And as they get into those instructions and the reasonable doubt instructions, they will be told if there are 2 reasonable interpretations, you must pick the one that points towards, and I think in Massachusetts it says not guilt. The exact word may be innocence. I do not remember. But if there are 2 reasonable interpretations, and he'll say, if there are 2 reasonable interpretations, you must pick the one that points towards not guilty. So when he has witnesses on the stand and he's asking, is it a reasonable interpretation, this or this, then he is building those stair steps to the eventual closing argument when you hear reasonable here, reasonable here, reasonable here, and he weaves it into his questioning. So for this witness, is it reasonable that it's undetermined because it could be multiple things?
You could take a look at it, and when you've had a fair opportunity to look at it, you can just look back up, and I'll proceed at that time.
So we'll see if there's a reasonable explanation or not.
Well, I've never seen this picture before, but I know what it's depicting.
Thank you. What is depicted in that picture?
It's a picture of 2 individuals standing in a morgue setting, which looks very similar to our morgue at the Cape Cod office.
Very good. If you could just hold that for a moment, and with the court's permission, could I publish that for the jury?
Okay.
Thank you. Mr. Wolf? And if you could please zoom in on the 2 individuals in that picture. Dr. Scordi-Bello, do you recognize any of the individuals in that picture?
I do.
To be perfectly honest, no, I don't.
With regard to the person on the right, do you recognize that person?
No, I don't.
The jury doesn't know what Proctor looks like, by the way.
Did you make any considerations at all regarding Grass in regard to your autopsy report?
This is probably better for their expert than her.
I did not
Right. She
see
said that.
any Grass. No, I did not make any determinations.
And was Grass at all even a consideration in your analysis?
I had very limited information as to the exact nature of the surface at the time of autopsy.
So the answer is no to that question. Any other potential causes other than ground, did you consider any other possibilities that could cause the type of injuries that are depicted on the screen?
There's a number of possibilities that could cause the injury.
Right.
My question is, did you consider, not whether there are, but whether you considered them at the time you were performing the autopsy?
I'm always considering at the
That's why
time
it's
of autopsy
undetermined.
what could have caused a certain injury.
That's
Did
why
you
it's
put in your
undetermined.
notes or your autopsy report any of those considerations? Are they documented?
Yes, she said it was undetermined. It's
Now,
not-
in terms of differential
there are multiple possibilities. Ergo, one possibility was not chosen. Ergo, it's undetermined. It is day 16 of the retrial of Karen Read. The court is at the lunch break, and they finished up with the first witness this morning, who was the last witness of the day on day 15, with a remainder of the cross-examination, a redirect, and a brief recross. And then the Commonwealth called the coroner, Dr. Scordi-Bello, who is now on cross-examination. And what was really interesting in this cross-examination is that there are times in a retrial you think you've seen everything, but alas, there is still new information. And what we saw, though I don't think we have answers for yet, and I am waiting, is a photo of two law enforcement officers at the medical examiner's office. The doctor said at the morgue, it has not been clarified well for me whether or not the morgue encompasses the entire building or if the morgue is just the storage portion of the office, because normally you would have the morgue, which is the storage, and then you would have where they perform the autopsies. And the photo to me is very clearly Michael Proctor and Officer Keefe. Remember, Officer Keefe testified that he was the only one that attended the autopsy. No one else was with him. And I was like, how in the world does the lead investigator or case agent or whatever not go to the autopsy in the death of a police officer? I was not pleased with that information and kind of surprised by it. Did not remember that from the first trial. And lo and behold, there is a photo. Now, it is not clear to me exactly when that photo was taken. It is not clear to me if that photo is from the time of the autopsy or not. But there is a log, we are told, where any law enforcement that attended would have to sign in. So I am waiting for more information on that. But it's very interesting that this photo appeared with who clearly looks to me like Trooper Michael Proctor. But this jury doesn't know what Trooper Michael Proctor looks like yet. They haven't seen him testify. They've only heard his name. And there is some other information that we learned in the first trial that we have not gotten into in this cross-examination, and I don't know if we will. Could law enforcement have gone to the coroner's office more than once? I suppose they could. We didn't hear that testimony from Trooper Keefe when he testified. He said he was there alone. So when is that photo from? Because it's clearly at the Cape Cod Medical Examiner's office. Was that during the autopsy? Was that not during the autopsy? I want to know everything. But the defense, through Attorney Alessi, on cross-examination is walking through not only maybe taking some preemptive shots at the prosecution's expert, but also asking some questions that will solidify things that their experts have done. We've talked in cross about pattern recognition, and we've heard them talk about Dr. Stonebridge, who we saw testify at the first trial, who is the neuropathologist who examined John O'Keefe's brain after the autopsy that was sent to her in Boston, and then she did that evaluation. Is the prosecution not going to call her and rely on their neurologist expert and not on the neuropathologist? Well, if they do that, we've seen a lot of testimony from a kind of enthused Dr. Scordi-Bello about the general badassery of Dr. Stonebridge. So after we've heard about Dr. Stonebridge being triple board certified and being just all kinds of amazing, if the prosecution doesn't call Dr. Stonebridge, it will be very interesting to see who they call instead, maybe their expert, and if that person is also board certified from here until infinity and beyond. But at this point, I'm rooting for Dr. Stonebridge. Why? Because I really found her very interesting first trial. And I liked her testimony. And I thought it was really cute when Dr. Scordi-Bello is like, oh, no, I know that. I can answer about what I know of Dr. Stonebridge and all her qualifications and how great she was. It was a nice moment to see the genuine enthusiasm for the brains that is Dr. Stonebridge. I also wonder if the Commonwealth was objecting to Alessi calling Dr. Stonebridge the brains of the brains is because they don't intend to call her. We're going to have to see how that plays out, because I'll be grumpy if they don't call Dr. Stonebridge. I like Dr. Stonebridge a lot.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries
There's a different way to go about
consistent with
that.
a motor vehicle accident?
I'll allow that.
There's a different way to ask that, but
Yes, I did examine his
Should have
lower
had-
extremities.
have
That is
had that info.
protocol in any case of suspected impact with a motor vehicle.
Right.
So I did examine his legs, and I did not see any evidence of an impact site.
You were shown a photograph of two individuals that were
This I
in
wouldn't
the
know about.
room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were
so that was at the time of autopsy. There's the answer I have been curious about. Two individuals that were in the room at the time of autopsy. Remember we were talking about the log? I don't know if this is the actual log, but he asked her to take a look at it.
Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Coroner.
She said Mr. Keefe and Mr. Connor, but wasn't the trooper's name Connor Keefe?
Isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
It's like, right. But also, totality of the circumstance is what she was going with. But the defense is
Attorney
going
Brennan
with doubt.
asked you
right?
questions moments ago, and actually several of them, of which included the words, did I hit him, could I hit him? Do you recall those questions?
This part.
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
And it
So-
didn't change your mind. Did you hear how excited he is?
Even though
But that didn't change your
you
mind.
had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
We're at the end of day 16. Let's try to summarize. The end of the coroner's testimony, I think, was a real interesting choice on the part of the prosecution. They started asking the coroner, did you know that all these individuals said that Karen Read said, I hit him, I hit him, I hit him? Did you know that Karen Read said she didn't know how she cracked her taillight? Did you know that people were drinking? Did you know? Did you know? Did you know? And for most of the responses, the coroner said, yes, I was aware of that information. There were very few things that the coroner said, no, I was not aware of. And those involved media reports that Karen Read had given after the fact, etc. So it just set up the easiest layup for Mr. Alessi when he got to recross to just say, so you knew I hit him, I hit him. You knew what Karen Read said. You knew that she mentioned her taillight had been broken. You knew all of this. And your finding was still undetermined, which is why I was so surprised that the Commonwealth just laid up that line of questioning, because the Commonwealth essentially laid out almost their entire case for the coroner. The coroner, who testified very well, said, I did know all of that. And this was still undetermined. She talked about the fact that they checked John O'Keefe for all the lower extremity injuries you would expect to see in a vehicle collision, and he did not have any injuries that you would typically see from a motor vehicle collision. The jury left today with the coroner saying, I knew all of this information that the jury also knows, and my determination of manner of death, how John O'Keefe got the injuries that caused his death, was undetermined. So though cross-examination for Alessi was a bit of a fizzle, and I actually yelled, don't end it like that.
Thank you for answering my questions.
That's Alessi.
Dr. Scordi-Bello.
You can't just give up and end on a sustained objection. There are other ways to ask it. He's just like, okay, fine. The end of recross was a huge win. But that huge win was completely set up by Attorney Brennan. And we're not even talking yet about the massive conflict about who was at the autopsy. Because the defense brought up a picture of who sure as fuck looks like Trooper Proctor to me and Trooper Keefe. And they finally brought in the log. And do you know what it says on the log, according to the medical examiner? That there were two names. And she said Mr. Keefe and Mr. Connor. And to my remembrance, wasn't Trooper Keefe named Connor Keefe? So now I want to know if they signed two different names or if he put his name on two different lines. And it seems, at the end of today, it seems that Trooper Proctor was at the autopsy. But I remember that Trooper Keefe, the junior guy, said that he went to the autopsy alone.
You attended the autopsy of John O'Keefe on January 31st of 2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
Because I was damn near apoplectic that the IO wouldn't even bother going to the autopsy. But lo and behold, when asked about that photo, Brennan specifically asked the coroner, who were the two people there with you during the autopsy? She said, I don't remember their name. It came back up on redirect that there were two. Oh boy. Well, the issue of who was at the autopsy by itself might not be the world's biggest boom goes the dynamite moment, but when you look at everything else in this case, it is one more thing where you have Trooper Keefe saying, I went to the autopsy by myself, and then lo and behold, there's a photo. And the thing is, wouldn't the prosecution have had that photo before that trooper's testimony? I am very interested to see how this all sorts out. And I want to know what badge numbers are on that log. I've got more questions about the damn log. Tell me about the log. I think I'd have a little bit more grace for it if the trooper hadn't testified that he was alone. I thought we were just going to be summarizing the testimony from the coroner. Nay, because after the jury was dismissed just a few minutes early, well, the attorneys went back on the record to fight more over the experts and what is going to happen with the experts. And when Alessi started, it was regarding the Commonwealth's experts dropping a new report. That was the first issue. What's going on with the Commonwealth's experts and a new report that the Commonwealth says was turned over May 8th. The defense said they got it May 11th. That was the first issue. The second issue was, well, we're talking about experts, and can we talk about issues with experts without talking about ARCA? We're at bravo fucking bravo levels of drama in the courtroom talking about who will testify, when, what, and how. And we did hear Alessi say at one point, ambush has been leveled against us. But what is happening with the Commonwealth? And the Commonwealth said not to level more disparities, but this is what's going on. And can ARCA be allowed to testify to all their new stuff? And can't the Commonwealth split their expert is essentially what they were asking for, and to allow their expert more time to review all the new discovery from ARCA, which the court previously said the Commonwealth will be allowed time to let their expert review ARCA information. So let's start with ARCA first, and even though it was the second issue addressed, and then we will just jump back because time is wibbly wobbly and clocks lie. So with the ARCA issue, that was the second thing that the court took up. The Commonwealth was arguing that they have not had adequate time to review all the ARCA reports, that the ARCA reports are voluminous. They are many, many gigabytes. ARCA did their own experiments and their own new this and that. And the Commonwealth expert, and the Commonwealth has raised this numerous times, the Commonwealth expert needs more time to review and rebut all of ARCA's information. But what the Commonwealth suggested was, well, we got ARCA's information May 7th. Our expert has not been able to finish reviewing it. So if our expert testifies at the end of this week or even into next week, we need our expert to be done reviewing ARCA's information before they're done testifying. And the court had said one of the things with ARCA getting all the information in is that the Commonwealth would need time to review. So what Brennan suggested was we should be able to split this witness, bring this witness in, allow them to finish reviewing the ARCA evidence, and then bring them in as rebuttal as well. That is not going to fly with the defense, who said immediately, Your Honor, this remedy is not a remedy. The only reason ARCA was doing new information is because ARCA needed to rebut what the new experts for the Commonwealth had to say. Aperture. The Commonwealth experts are Aperture, the defense experts are ARCA, and everyone's going like this. So the defense is arguing you can't let them split their testimony. They essentially are shifting the burden. That was the defense's argument. Your Honor, this is prejudicial to the defense. It is unfair because what you're suggesting is the Commonwealth expert testifies in their case in chief and then pauses. Then ARCA gets to testify. Their expert gets to keep reviewing things, and then their expert gets to testify again in rebuttal. The defense is not happy with that solution because they want all of the Commonwealth's information locked in before ARCA testifies so ARCA can rebut the Aperture testimony. But if the Aperture experts keep reviewing the ARCA information and then want to bring it up in rebuttal, ARCA can't have Aperture's new rebuttal information to review so they can testify about it. So we are now in a complete circle of, well, we're just responding to them. Brennan again raised the fact that the court was allowing the late discovery from ARCA to come in and saying, Your Honor, we keep saying this is late discovery. They dropped a ton of late discovery on it. The court found a discovery violation as to the defense with regard to that, but said that the remedy was going to be to turn it over by May 7th and to allow for a voir dire. Did Brennan use his voir dire to ask about new opinions, new testing, and what ARCA was doing? No. He asked about signal chats and who had lunch with whom. That's what he asked about. Now, at the end, the court did cut him off. He didn't even start down that path. So he had time, but ARCA wasn't done with their reports at the time that he did that voir dire. So the voir dire went into more communications than into determinations. So we are now in like a blue screen boot loop of whose experts are going to testify to what and how. So with regard to ARCA, the defense does not like the prosecution's suggestion that their expert testify, then ARCA testify, then their expert gets to go again. And the Commonwealth is arguing that their expert has not had time to review ARCA's information, which is a legitimate problem. The Commonwealth's expert should be able to review all of the defense expert information before they testify. And the timing on that got real close because it wasn't even turned over till trial was underway. And the court knew that was going to happen. The Commonwealth knew that was going to happen. The Commonwealth complained about it, and the court said, you're going to have to figure it out. We're not going to tell the defense that ARCA can't testify. But if they try to split the baby, it could create an unfair and undue burden for the defense. As I previously stated, do you see how we're in a loop? Because then the defense is like, well, if ARCA hasn't seen all their results, they can't address them. This is why there are discovery deadlines, so we're not doing this. Yet here we are. The first issue that came up was about the Aperture experts for the Commonwealth and whether or not they changed the time of impact. When Alessi started, he talked about the aperture experts dropping a new report on them May 8th, but they say they did not get it until May 11th. The issue with that is that they are using those timing reports or the impact logs that are numbered, and those logs, they are corresponding to a time this testimony got very nuanced during trial number 1. But they are taking, I think it is the keystroke log number 11/6/22. And in previous reports from the Commonwealth's expert, they had pinned the time of that event to between 12:31:38 seconds and 12:31:43 seconds. And they said that was in slide 137 of the experts' disclosures to them. And remember, the defense already fought over these expert disclosures, saying there's 400 slides of all kinds of stuff, but no opinions. So the timing from that particular log was between 12:31:38 and 12:31:43. The new report on May 8th shifts that time to 12:32:16. And the defense alleges that the new report indicates that the Commonwealth expert aperture is aligning, it's the exact words the defense used, aligning their time estimate to Ian Whiffin's testimony during this trial. And the defense brought up one of the numerous issues for them is that Ian Whiffin's already been cross-examined at length about time and the last time that John O'Keefe interacted with his phone, because the last time John O'Keefe interacted with his phone is incredibly relevant if the Commonwealth is arguing that he was struck between 12:31:38 and 12:31:43. If his phone is showing him still doing things after that time, the defense expert is going to say the injuries to John O'Keefe would have rendered him immediately unable to manipulate his phone or anything of the nature. That is what we expect to see from the defense experts. It's why the defense was getting into those questions today with the coroner, saying, with this injury, could someone have control of their hands, their arms? Would they have been moving, or would they have been rendered immediately unconscious and unable to have any volitional, intentional bodily movements? And Alessi argued our cross-examinations have been built very specifically around the reports that we have. And the reports that we have very specific timing. So to get a new report that now shifts the time from that 12:31 time to the 12:32:16 time to align with Whiffin's testimony, they say undermines everything that they've already done in this case. But the defense is not asking for this case to be a mistrial. Why? Because if they ask for a mistrial and the court grants it, this just starts over again. It doesn't resolve anything. They did not ask for the case to be dismissed. Do I think the court would do that at this point? Unlikely. And that's not what they asked for either. May they put together a motion in writing and ask for that between here and tomorrow or the end of the week? They may. They very well may. But they haven't yet. What Alessi asked for was more time or to exclude the new report. And then Brennan got up and said, Your Honor, this isn't new information. I said in my opening that there were different clocks and the clocks were wrong. The clock on Waze versus the clock on the cell phone versus the clock on the Lexus, the clocks are wrong. And our expert, Aperture, reviewed their expert, who the closed captioning just calling Mr. Disorder, and I think that that is hilarious, but I think it's Mr. Desorba, but that is a defense report. So the Commonwealth said, our expert looked at their expert report and found that their expert was wrong and then shifted their report. The defense is saying this is preposterous, not their words, mine, because the Commonwealth has known about the issue with the clocks for at least 6 months. Though I remember this issue about the 3 clocks inside an iPhone coming up in the scientific testimony in the first trial. When we were talking about the timestamps of thing, it was what memory used what clock. it might not have come up specifically to this issue and to John O'Keefe's phone, but the issue of the clocks potentially having, Tokyo drifted in time did come up in the first trial. So the defense's argument is this isn't new. This isn't new information. And the Commonwealth did not give us this information before trial started, and they should be precluded from using that information. And the court asked, what is the other option if we don't preclude it? And the defense said a continuance. We need more time. What would a continuance look like? It would look like more dark days in court where they are not in court. And the jury is like, hey, come back in a week. Do I think the court's going to give them a week-long continuance? Probably not. Could the court exclude it? They could. Would the Commonwealth lose their minds? Yes. What is the result that is least likely to result in an appeal if there is a conviction is one of the things that the court is going to look at. And the result that least likely becomes a problem on appeal if there is a conviction in this case is to disallow the Commonwealth from using the updated report to tell the Commonwealth that they can call their expert at the very end of their testimony and not allow them to split their expert testimony regarding ARCA, or to give a brief continuance, maybe a long weekend, like a Friday and a Monday off, to allow the experts to get caught up if they could do that. Those are the least problematic for appellate issues results. But the defense might ask for more. They might write up motions and ask for more. This just came up today. It's May 15th. The defense has had this report, they say, since May 11th and have not brought this up yet, but we are getting closer and closer to these experts testifying. The defense also confirmed in court that their defense they expect will be about a week and a half, all things depending, and that ARCA will testify towards the end of that. I think the court asked that question to attempt to gauge how much time the prosecution might need. Because if the court keeps out the issue of the clocks and the drifting clocks, then that is separate and apart from the Commonwealth's expert having a right to review ARCA's new reports. And the Commonwealth's expert does have a right to review those reports, and they knew timing was going to be crunched on that. But they're probably just going to get crunched on that. And if their expert is unavailable, that is going to be unfortunate, but their expert is going to have to find a way to either review those or not. So the court may well give a little bit of time for that. Or, could the court allow the Commonwealth's expert to testify after ARCA? Not in its entirety. I don't think you can, because that's not the way that the order of evidence is supposed to come in. This is not the end we're going to hear from it. The court did not rule from the bench. The court said at one point, this is the information that we needed, but the Commonwealth is in a pickle as to ARCA. They do have a lot of information that their expert needs to review. There are reciprocal discovery deadlines for a reason, but the Commonwealth is going to have to sort it out. The court might give them a little more time. That's a different issue. The new report, when the defense has already cross-examined numerous witnesses on the timeline that the Commonwealth has provided, is a issue for the defense that is at the Commonwealth's hands. And I think the easiest result for the court is to exclude it. We'll see what the court decides to do with that. I don't know if the court will give a continuance, because a continuance doesn't fix the fact that the defense has been doing cross-examination based off of the reports that they had. A continuance can't fix that. So I won't be too surprised if the court agrees with the defense on that report or decides to ask a few more questions about why that wasn't done sooner. Because as Mr. Alessi pointed out, the Commonwealth also said that they were surprised to receive that report as well. Well, if you're being surprised by your own expert, then did you ask your expert to do something? Did you know they were going to make a new report? It's going to be interesting to see what the court does. Is all of this going to get resolved like tomorrow? Probably not. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.